everyone. Thank you so much for joining us for our webinar today. My name is Dustin Saldarriaga, and I'm an immigration attorney at Scott Legal PC. Today, we're going to spend some time talking about the EB-2 National Interest Waiver, also known as the NIW green card. It's an underutilized category and one that we've started to see more and more people use to get a green card, especially entrepreneurs. Today, we're fortunate to have Jie Huang speak with us. Jie is a senior associate with the firm, and she has a significant amount of experience preparing EB-2 National Interest Waiver petitions. A few things before we get started. Our firm is a full-service immigration firm. Though we have a focus on business immigration, we do handle family immigration, humanitarian immigration, really all aspects of U.S. immigration law. So don't hesitate to reach out to us. We'll continue our webinar series by doing at least 2 webinars a month, and we do these webinars on a variety of topics. At the end of this presentation, we'll be reaching out to all of you by email with a link where you can sign up for future webinars. And I'll also say that on our YouTube channel, we post the full recording of our webinars, as well as shorter videos on a variety of immigration topics. So do check out our YouTube channel, which we'll link to in the email that we'll send after the presentation. After the presentation, we'll also send the PowerPoint that you see on screen. We'll send a comprehensive guide to the National Interest Waiver. And as I mentioned before, we'll send a link where you can sign up for future webinars. If you do have a question during our presentation today, please feel free to use either Zoom's chat function or the question and answer box on Zoom. I'll be monitoring those, and I'll share them with Jie either at the time the question comes up, if it's relevant to what Jie is talking about at the moment, or I'll save them until the end. But we should have time to get through all of the questions, so please don't hesitate to send those in. And finally, as I mentioned before, this webinar is being recorded and will be made available on our YouTube channel. Without further delay, I will go ahead and turn it over to Jie.
All right, thanks so much, Dustin. Okay, so why don't we get started then? We can look at generally about the National Interest Waiver, do a quick overview. So the National Interest Waiver is a great option. It is one of the few categories that someone can self-petition for a green card without a U.S. employer or sponsor. For that reason, it is very popular and have been used increasingly by professionals in a variety of fields, including entrepreneurs. So let's perhaps go over the requirements. The first thing to note is that the NIW is a subcategory of a more general employment-based green card category, which is the EB-2 category. So the NIW, by that, it means that the labor certification process that usually goes with the EB-2 category is waived because someone's work is in the national interest, it has substantial merit, the person is well positioned to do this endeavor, and because on balance, it would benefit the United States to relieve the person from those requirements to get a labor certification. And another thing that is important to note is that, yes, an individual can self-petition if they qualify for the National Interest Waiver instead of going through an employer sponsor. So that is the main difference with the general EB-2 category. Now, it is important to note that there is a threshold requirement to get into the EB-2 category in the first place. And that means someone should show that they have an advanced degree, which is defined as a master's degree or above, and it can also include a medical degree or a JD for a Juris Doctor degree or an MBA. Or you can also show that you have an equivalent of an advanced degree by showing that you have a bachelor's degree and 5 years of progressive work experience in your field following the bachelor's degree. So that is another way you can meet the advanced degree threshold. Now, what if you don't have a bachelor's degree? What if you just went to high school, or what if you got a different degree, such as an associate's degree or something like that? There is another way you can meet this threshold requirement, and that is through showing that you have exceptional ability in your field. And you need to show that you meet you can provide evidence under at least 3 of the below categories of evidence. For example, a degree related to your field that doesn't have to be a bachelor's degree. You can show that you have 10 years of work experience in your field. You can show that you have a license to practice in your field, or membership in a professional association, and that you have been recognized by your significant achievements to the field by your peers, government entities, or other relevant stakeholders. But overall, you do need to show that you are performing at a level that is significantly above the average in that field. So if you succeed on meeting those criteria, you can also qualify under the EB-2 category, which means you do have access to the National Interest Waiver. So the second part of a National Interest Waiver eligibility requirements is demonstrating that you do qualify for the NIW itself. And by that, there are 3 different requirements that you have to meet. And please note that you need to meet all 3 prongs of this National Interest Waiver test. And this analysis is defined by a case law called Matter of Danazar that came down in 2016. And so the prongs go as follows. So the first prong of this analysis is that a proposed endeavor must have substantial merit or national importance. For example, an applicant could be developing a particular type of technology. The applicant could be consulting government agencies on a particular topic, such as counterterrorism, cybersecurity, or anything else that is important to national security. An applicant could be developing medical advances or developing technologies that could improve manufacturing processes, for example. And for those kinds of endeavors, the government is likely to say, okay, this is a proposed endeavor that has substantial merit and national importance because the impacts of these endeavors are likely to be large. So the second analysis, the second prong, would be focused on the individual. And the government will ask, is the individual well positioned to advance this proposed endeavor that has substantial merit and national importance? And please note that the endeavor should first be found to meet the first prong in order to get to the second prong analysis, right? So in this part of the analysis, the government will be asking, what has the individual done in the past? What is their education? What is their past record of success? Has this individual worked in similar projects in the past that has gotten such great reviews from the industry or the media? Has the person done similar research in the past if the individual's endeavor is related to research? So those are the things that you should be asking when you're looking at your petition. And finally, the third and last prong would be, on balance, whether it is beneficial to the United States to waive the labor certification process. And practically, if you already met prong 1 and prong 2, especially for entrepreneurs, it is a quite strong case that we have to meet prong 3. And the reason for this is that the ordinary logic behind the government's labor certification process is to protect the US labor supply. But in the cases of entrepreneurs, this logic doesn't really apply because entrepreneurs are not taking a job away from the US labor market. Rather, they are creating more jobs to the labor market and hiring additional people in the US by developing their business. So, and in another part of the flip coin, entrepreneurs, they own in many cases, they own majority stock in the company, and therefore they cannot have their own company sponsor themselves for the labor certification process. So they're practically ineligible for the labor certification process. So for many of these reasons, for entrepreneurs, it is quite a strong argument we can make to meet the third prong. That on balance, it will be beneficial for the US to waive this requirement for entrepreneurs.
Perfect, Gia. And I just advanced the slide if you want to go ahead. I don't think any questions have come in, but I am monitoring those. So any of the participants, if you do have questions, feel free to share those.
Great. Perfect, Dustin. All right. So we will keep moving on. So how can the National Interest Waiver be used for entrepreneurs? So with the new case, matter of dinosaur, the case included a lot of language that is favorable for entrepreneurs. So there are a lot of arguments that entrepreneurs can make to strengthen their NIW case. One of the changes that was made in the case law is that the analysis no longer focuses on geographic scope. So an entrepreneur can have a business that only hires workers in a particular geographic area, but their endeavor could still be found to be in the national interest. For many reasons. You could either be providing employment in a particularly economically depressed area with high unemployment rates, or you could be developing technological advances, for example, that could result in advancing the best practices of a field as a whole. In that case, there is no geographic limit to the impact of your work. So that has become a favorable change. And Dinosaur is also the case that introduced the language that they explicitly recognize that entrepreneurs will not be able to use the labor certification process because if they own a majority stake in the company. So we can go ahead and use that language to support the third prong. On balance, it is beneficial for the United States to waive the labor certification requirements for an entrepreneur. So, and another favorable change that came down with the matter of Dinosaur is that the focus of the national interest waiver analysis is on prospective impact of entrepreneurs' work. So you do not need to show more than likely that your entrepreneurial endeavor will eventually succeed. Rather, you need to show that the plans that you have, if they become true, will have such tremendous impact. So you don't have to have a venture business that is already up and running. You can qualify for the NIW based on a planned venture or a venture that is about to start. You do have to satisfy that you are well positioned to advance this endeavor, which means you will need to have some sort of related record of success or related experience to convince the government that you will be the best person to advance your plans. But technically, yes, you can be approved for the NIW even if your endeavor has not started yet. And we have had approvals for those types of startup endeavors.
Perfect. So GA, we do have a few questions.
Yeah.
So can you talk a bit about whether an entrepreneur who's considering the NIW needs, and you did already mention this, is there a benefit for an entrepreneur to have an established company versus a startup versus even just a business plan? And can you talk about the relative strengths of applying through each of those three situations?
Very good question. So I guess I'll start with when an entrepreneur has an established company. So the benefits of that is really when this enterprise is already going well. So if you've already been working on your project for a while, you will have contracts that are ongoing with prestigious entities, government agencies. For example, if you are a developer for architectural innovations and your services are needed by the government of New York City, for example, like that's a great contract that you want to showcase and say, hey, I'm doing something good in my industry and the government has been asking for my work. So that can be a very positive aspect for an entrepreneur who already has an endeavor up and running. And now let's consider then a startup. So if you are just starting it up, right? And if you have, if you can show certain expressions of interest in your endeavor once it gets operational, but you have a business plan and you have some investments in it, maybe you have earned incubator admission or accelerator admission for that idea, but it's not up and running yet. Yes, that is certainly great. And pros of that is that you can really make the endeavor anything you want, and you're not tied to a certain business plan, business model, or a certain area that you were working with beforehand. So you can certainly start up a brand new idea, perhaps that matches up better with what the government thinks is important at the moment. For example, like, environmental sustainability is a big priority for the government these days. So if you can sort of pivot there, that could also be a great way to qualify for the NIW. But as again, the well-positioned prong is also a challenge. You need to show that you do have the right knowledge and the right experience to make this endeavor happen. And so the third scenario was if you just have a business plan and you don't really have much traction around it yet. Now, for those kinds of cases, I would say it is more of a risky case. I would want to, if I were the applicant, I would want to talk to prospective clients, talk to prospective business partners, and try to get at least several expressions of interest from U.S. entities. Major entities, the better, in order to show that there is some traction for your work in the U.S. and it's just not based on a single business plan and not supported by any other third-party evidence.
Perfect. That's very helpful. And sometimes I think when we talk about the NIW, we tend to focus maybe even a little too much on entrepreneurs. So can you talk about when an NIW may be a good option for someone who's not an entrepreneur?
Oh, for sure, for sure. So in my experience, usually when it works best is if a particular professional has engaged in research projects that have advanced the cutting edge of the field that they're in, whatever field that may be. It could be computing, it could be semiconductor, it could be geographical science, or it could even be philosophy. But usually you need to show that someone's work in that field has engaged in broad benefits, right? And so that is, I think, is the key here. Like, have you engaged in work that can arguably be said to have pushed the envelope for the field as a whole? And if so, and if you have received recognition for that, yes, absolutely, NIW is within your reach. Another big category of applicants for the NIW are academic type people who write a lot of papers and get citations for their work. And citations is a very popular way to show that your work has generated such impact to advance the best practices of the field. So that's another way people approach NIWs.
Perfect. And a couple of questions that have come in are around the theme of, I work as one person says, cloud computing professional. I work as a user experience designer. When someone comes to you and they say, this is my job title or this is my profession, how do you think about that prong of the NIW requirement of the substantial impact? And to put it specifically, are there categories of jobs or professions that just the government does not find they have national importance or substantial merit? And how, if someone comes to you, how do you frame it to convince the government that it does have national and substantial importance and merit?
That's a very, very good question, a very complicated question as well. So the important inquiry here, again, is when a potential client comes in and says, okay, I'm a computer engineer. I'm like, okay, great. So what do you do? What are some of the most impactful projects you have worked on in the past? Have you authored any patents? Okay. And so I would ask to get more information on what the impact of their past projects have been, because it will, I think, be hard if that person has just been providing services to an employer, right? If that's the 100% of it, it's going to be hard to make the argument that their continued work in the U.S. is going to have a more broader impacts than just benefiting a single employer. And there has been a case law that has said the purpose of the NIW is, quote unquote, like not to help somebody engage in a US job search. So that is very unfavorable language. So we want to move away from suggesting that this person is just one individual providing services for one employer. So in order to counter that, I'm thinking creatively, like, what can we talk about in terms of their prospective projects and their past projects that have resulted in industry-wide progress. Okay, so that's kind of the inquiry that I would do. And there is no one category of job that is off limits for NIW, and I have seen of approvals for actually designers, user experience designers, actually. And the way that we built that argument is to cite some examples of where their product was actually implemented in a very popular mobile phone brand, and you can also show numbers of how many devices were sold and if that device has gotten any awards or media attention for those user experience innovations that could have helped in providing more support for national impact, national importance through substantial impact to the industry. But without those kinds of case studies that we can work on, that would be a riskier and weaker case.
Great, that's very helpful. And I think, kind of one of the broad, if I can make a very broad statement and kind of in some ways, a summary of what you're saying is
right.
The NIW, I mean, it really is an opportunity to advocate for yourself. It's not the time to be humble. So
right.
If your job is in cloud computing, if your job is in user experience design, this is the time to kind of say, how do I put myself in the best light possible, obviously while still being honest and accurate, but really advocate for myself and show just how important my work is and the impact it's had. So Gia, questions are rolling in and a number of good questions.
Okay. Great.
So one of the questions about a startup, if the business in the US would be a startup, but the applicant does have a business abroad, does that play in? Is that material? Would you typically highlight that in the application or no?
That would certainly depend on how the foreign entity is doing. So if that foreign entity has engaged in high-profile projects with the local government there in the foreign country, if that foreign entity has done some innovative work that has been highlighted by media, or even if you have authored intellectual property in the past connected to this foreign entity, I would certainly highlight all of that. That is good evidence that your startup in the US will continue to be successful. Now, on the other hand, if the foreign entity has been running for many years, but the revenue levels and hiring levels were low, maybe best not to highlight that, because that may undercut our argument of broad impact, explosive impact to the level that we want to rise to national importance. So in that case, strategically, I would make a choice not to focus too much on that.
Excellent. Perfect. So Gia, I'm going to go ahead. We do have some extra questions. I'm going to save them for later.
Sure.
So that you can share a bit about timing and other considerations.
All right, great. So a very important update is that premium processing is now available for all new NIW petitions and also upgrades for any previously filed NIW petitions. In comparison, regular processing, it would take about a year to get a result on your I-140 NIW petition, and the green card application will take more time on top of that. And it is important to note that the premium processing part only applies to the I-140 petition itself. The decision or an RFE will be rendered within 45 calendar days. And once you respond to an RFE, if that was what was rendered, the government will take another 45 days to get you a final decision. And it costs $2,500 to make that happen. Timing considerations. So if you are already on a non-immigrant visa status, the timing consideration is important because once you file an NIW I-140 application, it is an immigrant visa application. So it could be difficult to renew your underlying non-immigrant status. And this is more so in the case of certain categories, such as the TN visa or an F1 student visa, where non-immigrant intent plays a very big role. So let's say, for example, if you're already in the US on an E2 or O1, for example, it could be a good idea to extend the status first and get another 3 years, get another 5 years, for example, and wait to file the I-140 until you have already extended that visa, and to the end that you have sufficient time for the NIW to process. Okay, so the application process for the NIW. So as I mentioned before, there are 2 elements to an NIW green card petition. So the first part is the underlying I-140 petition, which is really the assessment of the merits of whether you qualify for an NIW and EB-2 category. And the second element is the green card application that you can file based on an approved NIW I-140, or in cases of people who are already in the United States, you can file the adjustment of status application as soon as the priority date becomes current, even if you have a pending I-140 that you don't have an approval yet. So there are 2 ways you can approach the green card application part of this process. The first option is adjustment of status. It's also called the I-485, which is meant for people who are already in the US on a different non-immigrant category, versus consular processing, which is that you will, once your I-140 is approved, your case will be sent to a consular office in a foreign country, most likely your home country, and you will process the immigrant visa from there. And you will leave the US to attend the interview at the foreign consulate. And after you get the immigrant visa stamp, you will enter the US again and be an immigrant starting from that new entry. So there are some pros and cons of adjusting status in the US versus doing consular processing. So the first thing to note is it is important that adjustment of status is an option only available if you are already in the US in a different non-immigrant visa status. If you're living permanently outside of the US, then really your only option is to go for consular processing. The pros of an I-485 adjustment of status option is that you're already in the US. You can continue to live in the US while your I-140 and I-485 are both pending. And this is important because the I-485 adjustment of status application for a green card can take many years. So while those applications are pending, you can apply to get an employment authorization card that lets you work for any employer while your applications are pending. You can also apply for a travel authorization card that allows you to travel outside the US while these applications are pending. So cons of doing an adjustment of status I-485 option. So the first thing to note is that for non-immigrant visas, once you file the adjustment of status application, it will be very difficult to apply and be approved for another non-immigrant visa in the future. So for cases that are not a slam dunk case on its merits, usually what we counsel clients is go for a standalone I-140 and choose consular processing to preserve that ability to apply for a new non-immigrant visa in the future if needed. Another limitation of the I-485 option is that you are not able to travel outside of the US once you file the I-485 before you get approved for your travel authorization card. So that could also be many months, up to a year sometimes, until you can get your travel authorization approved. So that could be problematic if you are someone who needs to go in and out of the country a lot. Another thing that could be problematic to choose a I-485 option is if you have just entered the US on a different visa, such as let's say you entered on a B1, B2, and it has only been like 30 days, and then you suddenly decide to apply for an I-485, that would also not work because then it seems like you already had that immigrant intent to adjust when you were coming in as a non-immigrant visa holder. So that could also be problematic down the road.
Perfect. And yeah, what's underlying a lot of the complexity is that US immigration law, one of the fundamental ideas is that the government assumes that anyone who is coming in on a visa intends to stay in the US.
Right.
And the applicant has to prove to the government, has to convince the government that they don't
Right.
plan to remain in the US, that they're only planning to stay temporarily. So if you are coming
Right.
in on a visitor visa and you have a pending green card application, the government's very likely to assume you want to stay, and therefore they won't let you in on a visitor visa. So
Right.
I think, we do, and GA spends a lot of time working with clients in even consultations to walk through what is the best way to apply given your goals. It's one of the first questions we oftentimes will talk with clients about. What is your goal? What's your short-term goal? What's your long-term goal? And then we will work with them to kind of navigate that through these complexities.
Right.
What Gia is talking about really is a great example of when it is actually beneficial to work with an immigration lawyer.
Great point.
So GA, could you just briefly go over the fees again? I think there was some confusion about what the premium processing fee is versus just the standard filing fee for the I-140 and I-485.
Oh, yeah, sure. Yeah. So the premium processing itself is just 2,500 for that. And the regular processing fee is 700. Yeah. So if you decide to file the I-140 and choose premium processing, that's 700 plus 2,500. And if you just choose regular processing, it's 700 filing fee for just the I-140. But also note that there are different fees for the green card application portion, whether you go through the foreign consulate or whether you go through the I-485. The I-485 also has its own fees.
Perfect. And there's oftentimes confusion about what benefits the applicant gets when they file the I-140 versus the I-485. So
yeah,
the specific question, when someone files the I-140, can they stay in the US? Assume they haven't filed the I-485.
That is a very, very common misconception. And yes, I'm very glad you pointed it out. And the answer is no. Just filing an I-140 does not give you any status, extension of status or whatever. You are on the non-immigrant visa that you're currently on, and just filing the I-140 does not give you the ability to stay longer in the US, does not give you the ability to work in the US, none of all that. Those things can only happen after you file the I-485.
Excellent. And right now, there is a delay in terms of the availability of green cards for the EB-2 category. So, there might be time between filing the I-140 and filing the I-485. So that's something we can also, and GA can also work with clients to navigate.
Yeah, definitely. That is a very important distinction that you just made, because the concepts that we talk about is the priority date, right? And what we say is the priority date has retrogressed. And what that means is that currently, as of February 2023, only individuals that filed their I-140 before December 2022 can apply for the I-485. So if you file an NIW I-140 today, you cannot simultaneously file the I-485 with that application. And this is important because it didn't used to be the case. So many clients would file their I-140 and I-485 simultaneously. But recently, and this has been a very recent development, that has not been possible. So what you should do in that situation is first you file the I-140, and once your priority date becomes current, you can then file your I-485.
Perfect. Is an interview typical for EB-2 NIW applications?
So for the I-140 NIW part, no, the interview is not a part of that. The interview, if you apply for the I-485, there will be an interview. But that's mostly related to, adjusting your status. So they won't typically go back and redo all of the national interest waiver analysis. They really won't do that. That's not their focus. Mainly, they would just verify that all the facts are true and you're still working in generally in the area of your proposed endeavor. But yeah, there will be an interview at the green card stage. So, and even if you're doing consular processing at a foreign consulate, a foreign country's US consulate, you will be asked to do an interview. And in that interview, the consular officer will ask you all about your petition. They will ask you about the expert letters. They will ask you about your project. They will ask you about your experience. So you will sort of need to be familiar with everything that you prepare.
Great. And what about family members, spouses, and children? What benefits do they get through the principal applicant submitting the I-140 and the I-485?
Great question. So in the green card process, yes, you can include your spouse and your children, dependent children under 21 years of age to join your petition for a green card. And if you're approved for the green card, all of your dependents will be approved as well for the green card.
Great. And a couple other questions. I think this slide really got people thinking and prompted
Sure.
some good questions.
No problem.
So
yeah.
let's say you mentioned premium processing as an option to get a decision from the government on the I-140 within 45 days.
Yep.
Which is great because in the past that used to take months.
Yep.
Now, Kelly is asking, what if the business is ready to hire 70 people right off the bat? It's going to provide employment in rural areas. There's an urgent need for the business. Is there an argument that can be made to expedite the application with the government, or is premium processing the only option?
That is a very good question. And I think there is room to, make that argument. Now, there is really no guarantee on whether that will be honored, but I have heard anecdotally of cases where there was such urgent interest and the government rendered a decision quite quickly. And we also personally had a case approved in 1 month without premium processing. And I was very shocked to see that, but that happened. And I have seen other attorneys in the NIW practice area report similar success stories where in case there was such an interest, the government does sometimes expedite. But there is no particular different process for that. You would just, make that case in your petition. And if the government thinks it is compelling, they will issue a decision quicker. But it is not a formal pathway to that. And really the only way to guarantee the quick processing is the premium processing route.
Perfect. All right. That covers the questions for now. I'll save a few others for later in the presentation.
All right, perfect. Okay, so we can briefly discuss the updates to the NIW adjudication guidelines that came down in 2022, and specifically for people in STEM, science, technology, engineering, manufacturing, and entrepreneurs. So there were different sets of evidentiary criteria that were handed out for both these categories. So certain important highlights of those things. There is a list called the Critical and Emerging Technologies list that is published by the US government. And that has a list of certain attractive STEM areas where the government really is looking for talented individuals to come and advance. So this includes, for example, aero engine, agricultural technology, artificial intelligence, biotech, communications and networking, such as 5G technology, data science and storage, infrastructure and programs, energy, medical, and public health technology, quantum science, semiconductors, space technology. So those are some areas that the US government thinks is important for national security and national progress. So if you are working in those areas, this is certainly a document that you want to highlight, and that will help your application. With regards to entrepreneur-specific guidelines, the government published these alternative types of evidences that can help an entrepreneur support their case for an NIW. So, for example, awards or grants from government entities can be very helpful. You could submit letters from incubators, VC funding organizations regarding the merits of your work, and that will be considered a good evidence. You can also submit evidence that you have run your company in the past and generated significant revenue growth and hiring. Those evidences can also be relevant in proving that your endeavor will have substantial merit and national importance, and that you will be well positioned to advance your business endeavor. Incubator and accelerator participation. For example, if you got admitted to Y Combinator, of course, that would be amazing for your petition. Evidence of investment from third parties that could also support your case. Publication of patents and other forms of intellectual property, either by yourself or by the company, that could also work in favor for your case. And media attention on yourself and your company.
Perfect. So we do have a couple questions that I think are case specific.
Yep.
For example, I'm a part of this organization or this startup accelerator. For those, please do schedule a consultation. Those are the types of questions where we need to have a more detailed and personal conversation to really give you advice holistically, where we'd look at the whole application. So please do schedule a consultation if you'd like to discuss those questions. But GA, there were a couple questions that I thought were more broadly applicable. First of all, let's look at this bank statements and financials. Part of the application, is there any requirement that the applicant show the financials of, I'm assuming this is referring to the business,
yeah,
versus the applicant individually, but how do the financials of the business play a part in the application?
Yeah, so if the person has been running their company for a while, and if that is a part of the application, then the government will certainly want to see tax returns that show how much the company has been making and how many people you have been hiring. So that is a very important aspect we would certainly include. Now, the inquiry is a little different. If the past company, is not a big part of your application, then there may not be a need to show that. Also for startups, you can show maybe if you got investment from a third-party investor, you could show the agreement to invest. You may not need to show the actual bank account of your startup to show that the funds are there. So that's another distinction that is useful to make. For example, if you sold some stock to an outside investor, you can also have the stock purchase agreement as evidence of that investment, and you don't need to show your bank accounts or your P&L statement or anything like that to show that. So you can certainly be more flexible in cases of startups. Yeah. Excellent.
Couple of questions from Michelle. So let me see if I understand the question correctly. So I think she's kind of distinguishing, if you look at the business's track record, I think she's distinguishing the amount that she is personally paid as being the owner or manager of the business versus what the business is generating. So in an NIW application, what is the relevance of the pay that the applicant received from the business versus whatever is generated by the business itself, if that makes sense? And Michelle's question is, she apparently wasn't taking much from the business in terms of compensation. Does that impact the application?
Yeah, so I don't think so. I don't think you need to show how much you were taking personally to show that your business has been successful and has been creating revenues and jobs. So I don't think it's typical that you need to include your pay statements personally. You can just go with the corporate statements to show that your company has been generating revenues and hiring. But again, yes, it is a fact-specific question. So yeah, please feel free to schedule a consultation if you want me to actually look at those documents.
Great. And then a follow-up question she had, is it beneficial to have had a client in the US before you apply?
Right, usually yes. So if you have an already existing endeavor, and if you have contracts in the US, and if they are, contracts with major entities, major players in the industry, yes, certainly that will be favorable. There is no requirement, though, to do that. However, if you are proposing a startup, and if there is absolutely no interest from any US entities, that could be a riskier case. So it would be a stronger case to have at least several entities in the US wanting to work with you in your endeavor to show that your idea has traction.
Perfect. Thank you. And just a quick reminder that any questions that are case specific, like here are my circumstances, would I qualify? Please do schedule a consultation. A webinar, we really can't go into the details and look at your application holistically. So please do feel free to schedule a consultation with us, and we can certainly get into those details. So GA, let's talk a bit about what is included in an NIW submission.
Sure. So the NIW submission is a very paper-heavy application. So the more objective proof that you can come up with, the better. So the first piece that you will collect is that evidence that you meet the threshold requirements for the EB-2 classification. So if you have a foreign advanced degree, for example, you will also want to get a US education equivalency analysis report to show that your degree from the foreign institution is equivalent to a US degree of the same level. You may also want to include transcripts to show what kind of courses that you took that were relevant to your endeavor. If you are meeting the threshold through 5 years of progressive work experience after a bachelor's degree, you will need to get letters from your previous employers attesting to the duties that you played, your salary, for example, the period of work that you completed, in order to show that you actually did work those 5 years and that your duties were progressive. And by progressive, that means you were taking on senior duties as time went on. So it will not work if you stayed in the same position for 5 years. That will not count as progressive. You will need to show that your duties changed over time to be more responsible for more senior duties as time went on. And so if you are also meeting this criteria through exceptional ability, you will need to provide evidence that you meet at least 3 out of the 7 criteria for exceptional ability. For example, if you're arguing that you have 10 years of work experience, you will need letters from former employers that add up to 10 years to prove that. If you are arguing that you have membership in a professional organization, you will need to provide a certificate of membership from that organization or a letter from whoever is responsible that confirm that you are an active member in good standing. And if you have a diploma or associate's degree, for example, related to your endeavor, you will also want to procure a copy of your diploma and transcript if necessary. Okay, so the second part of what is included in an NIW submission are supporting evidences that you meet the 3 prongs of the matter of Danazar test. So, for example, to prove that your proposed endeavor has substantial merit and national importance, you will include a detailed statement of proposed endeavor explaining what you will be doing through your business. If you are developing new technology, you will explain in detail how this will improve upon how things are usually done in your field, and you should explain why this advances matters of national importance. Another important aspect are expert letters. Expert letters are important because you can use them to really support your argument of why your work in particular will advance the field as a whole, or or advance matters that the US government has expressed that is in the national interest, such as environmental sustainability or 5G network technology or things like that. So expert letters will explain both what you are about to do in the US and also explain the achievements that you've made in the past that make you the best candidate to advance this endeavor. So expert letters can support both prong 1, that your project is of national importance, and also support prong 2, which is that you are well positioned to advance the endeavor. What else? Right, for entrepreneurs, as I mentioned before in previous slides, letters of interest from investors, future clients, letters of interest from business partners can really be a strengthening factor for your application. You may also want to include proof of revenue growth and hiring, which will usually be demonstrated by tax returns showing how much revenue your company has made. You will also include copies of any intellectual property you have authored, or if the company has sponsored, for example, patents relating to technological advancements you have already made in your field. That can also be a very helpful strengthening factor for your application. And it is worth noting that there are no cookie cutter petitions. Every petition is very much personalized to the particular strength of the applicant. And that is what makes, that is often what differentiates from a petition that ultimately gets denied or a petition that ultimately gets approved, because NIW is a category that is very narrative heavy, and organization of the evidence is very, very important. It should be very strategic and well thought out.
Perfect. On that note, many people who are applying for NIWs have submitted applications in the past and might already have recommendation letters. Is it okay to recycle or reuse those old recommendation letters for the NIW application?
It depends. Yeah, it depends. I think it depends on what was discussed in those letters. Like, for example, if the expert letter discussed somebody's past achievements and that has stayed the same throughout the years, yes, you can maybe recycle that. The preference is that the expert letters are signed recently, just because you want to show that the experts who are currently active in the field, who know the current cutting edge of the industry, can attest to your the continuing relevance of your work. So if they're too old, probably not favorable, but really it depends.
Great. And when we talk about the evidence that's submitted, it can sound a little bit overwhelming. So can you give us a sense of how long does it usually take an applicant to pull together all of this evidence?
A very good question. We have, I would say we have prepared a complete application from beginning to end in 90 days. And I think that would sort of be the general benchmark I would give. But that is also assuming that, the individual is very motivated and pushing the case forward. And sometimes for some cases, we also give suggestions on how you can strengthen a petition, right? So in those cases, the client just goes back and works on business development or some other things to come up with more evidence. So in those cases, the process can elongate significantly. So we have ongoing cases that has been being in preparation for a while.
Excellent. A question about degree equivalency reports. So is there a requirement if someone has a degree from Mexico, Canada, or even a country outside of the Americas, how does a degree equivalency play out? Is it required, and if so, when?
Yes, it is always required if you have a degree from a non-US institution. So even if it is, a very famous university in Canada, for example, you still need to get the equivalency report. And it is very important, because without that, your petition can just be denied based on the fact that you don't meet the EB-2 criteria. So getting a degree equivalency report is very important. And sometimes the degree equivalency report will say, actually, your degree is not equivalent to a US master's degree. And if we get that kind of information, we need to re-strategize the petition, right? Because you need to either meet through bachelor's and 5 years experience, or if you need to go through the exceptional ability route. So that is a very important step that I encourage clients to go do in the initial stages of a petition, just so we know what we're working with.
Great. So GA, we have 6 minutes left. So why don't we turn to a case study and see what this looks like in practice.
Sure thing. So a very compelling case study I like to share is for an entrepreneur who wanted to set up a consulting firm to work with U.S. government agencies and philanthropic organizations to improve services that are given to U.S. veterans. And actually, this case was denied on the first go, and that's why it was flipped, and now it was approved on appeal at the Administrative Appeals Office, the AAO. And it is interesting because it can give us a general sense of how the analysis works on national importance, well-positioned, and on balance. So the person's proposed endeavor was that they wanted to improve the services given to veterans in linking the veterans to productive employment opportunities. They thought that the resources out there were not sufficient to give them the right information, the right support they needed to reintegrate to productive society. Okay, so in support of that, this person procured letters from senior officials in U.S. government agencies, businesses that affirm the importance of this work and also affirm how this person in particular can help make these better connections happen. And one thing that really helped with this petition is that this person already had like 10 years of experience doing these networking activities among US and UK organizations covering that field. So he had actually run campaigns that have resulted in millions of dollars being funded into these initiatives. And in another project, he actually was able to link more than 100 veterans to job placements. So those kinds of concrete evidences of past successes of his projects really made a difference in getting this case to approval. And with regards to the third prong, on balance, it is beneficial to the U.S. to grant the National Interest Waiver. One important consideration was that this person really had unique skills that really could not be replaced by another person in the field of philanthropy, and that the national interest in the work is so substantial and it's so compelling that this person, their endeavor would give broader benefits than saving one U.S. job from the market. So that was a strong argument towards meeting the third prong as well.
Great. One last question rolled in. In terms of the expert letters, does the government require an original signed signature, an original signature on the documents, or would you scan those and print them? Right.
So scanning is fine. The expert will sign the letter with a pen, and then they would scan the letter up to the computer, and we would print out the scanned copy, and that should be fine.
Perfect. Well, GA, thank you so much. And to all of our participants, thank you for the great questions and the active participation. It really does make for a better presentation. Keep an eye out for a link to our future webinars. We do hope to see you on our future presentations. And in the meantime, please do visit our YouTube channel and our website, where we try to make a lot of good, high quality information free to you all. So GA, thank you again. Everyone, have a wonderful day.
Thank you so much. Bye.